is that the court will follow the presumption that proceedings be public. However, we'll also follow Rule 15.4D, that Rule 15 materials are not deemed public. So we'll order that the parties file all Rule 15 related matters under seal, that they not attach any Rule 15 matters to pleadings, that they may be discussed as necessary in public proceedings, if we have to excuse a potential juror during voir dire because he or she can quote something that counsel have said outside of the courtroom, I will probably fine that lawyer the cost of that juror. And if we have to move this case to Parker, I'll fine them the cost of my hotel room. So with that as my inclination, Ms. Losico, is there anything that you want to add to your pleadings?
Nothing, Your Honor. Thank you.
The motion to oppose the intervention is denied. The court finds that the press has standing for this issue. Mr. Bodney.
Thank you, Your Honor. I certainly don't want to waste the court's time this morning, and if there are any open issues on the court's mind with respect to the public's right of access, I'd be happy to address them. I heard you to say that you are inclined to rule in a particular way. I would, as you know, I'm here on behalf of a half a dozen different news.
Get to the meat and potatoes. Let's forget the appetizer.
Okay. Well, I think there are essentially 3 points that have been made by the state, and they're all unavailing. The state's...
You won that part. I'm overruling their objection to your intervention. You have standing to argue it. I think you've won. I don't know, unless you want to talk me out of it.
I do not want to talk you out of it, and if the court is denying the state's motion to seal all the pleadings in the case, we are grateful for your time and thought and attention to the matter.
Okay. Mr. Lamb.
Your Honor, as a very minor point of clarification, I certainly am not going to try and talk you out of your ruling in any way. You had previously ordered, pursuant to Rule 15.4D, that discovery motions actually not be filed at all, that they be informally exchanged between the parties, and that is what we've been doing, Your Honor. A moment ago, you indicated that you wanted them filed under seal, so respectfully, I'd like some guidance and clarification on that point. And then lastly, you indicated that there were to be no Rule 15 attachments to pleading. If the need arises, shall we file them under seal as addendums to that pleading?
Yes, I see a distinction between, I don't want 4,000 Kalindas and Paul Drakes out there looking at law, Rule 15 matters, and now analyzing those things. So I believe is the public's right to know is there's a proceeding, a motion to dismiss, a motion to remand, but what you may use to support those motions be discussed in public forum. But people's phone numbers, any particular results of tests, they should be, if they are needed for the pleadings, they should be attached and filed under seal. I see Rule 15 as telling me, I don't get an agreement to dispute. So if there's an agreement between the parties to share emails without having to file anything, that's fine. But if there's going to be a filing of, I'm going to notice this particular witness with his phone number, her phone number, all of that should be filed under seal so that we don't have people knocking on people's doors, asking questions about a case. I'm going to do everything I can. We're going to spend every day with a juror telling them face to face that they have to make their decision based solely on the evidence in the courtroom. I want to make that as easy for them as possible. So Courtroom proceedings will be open to the public unless there's a particular reason, and you guys can file a motion for that particular reason. Pleadings can be filed, but any Rule 15 materials that are needed for those pleadings.
My only
should be
concern, Your Honor,
filed
is
to be
all of the
filed
pleadings that have been filed
Ms. Losico, any questions
prior
about
to
that?
this court. My only concern, Your Honor, is all of the pleadings that have been filed prior to this court making this order, which contain Rule 15 material.
Well, we could theoretically pull them back. I mean, I can ask the clerk to do that, but it'll be late in an instant. I would ask that the theoretically pull them back. I mean, I can ask the clerk to do that, but so we have less parity. It'll be late in an instant. I would ask that the tenor of the rhetoric, tone, and any other questions.
No, Your Honor. Thank you for the clarification.
Well, since you got the, let's do the motion for the expert. Do you have a job deadline for Mr. Haig to finish his work?
I do not have a deadline, Your Honor. I did speak with him yesterday afternoon, and he indicated to me that he needs approximately 3 more weeks with the items.
Is that because it takes that long to do whatever he needs to do, or is that because it's the 50th item on his things to do list?
It is a combination of both, Your Honor. He only received the items last week, and he does have some other cases. However, he did tell me in my telephone conversation with him yesterday that this is a priority. He is working diligently on the task.
What chain of custody arrangement have you made with Mr. Haig?
We have Mr. Haig met with one of the DPS troopers who is involved in the case to exchange the evidence. That trooper is in the process of drafting a supplemental report with respect to that exchange. Mr. Haig will continue to keep custody of the items. They will be locked. He has, in effect, what is comparable to a locked evidence locker. And then once he is done with the evidence, he will return it to that trooper as well, and that will be documented.
Can that be accomplished at another time with another expert? That same procedure?
Absolutely, Your Honor. However, the state would like that to be documented in the appropriate form, as I indicated in my response to defense counsel's motion.
Mr.
Your Honor, addressing that procedural issue, the state takes umbrage with the proposed form of order that was informally exchanged between the parties. Both parties have a right to that evidence, yet the state respectfully seems to be playing by different rules when the evidence was just handed off to its expert with the defense having absolutely no knowledge of it whatsoever. And the fundamental notion here is that due process allows both.
What harm is there for a 3-week wait before your expert gets stuff?
Well, Your Honor, at this point, Rule 8 time is ticking away. There has been and there will be no waiver of speedy trial rights on the part of Mr. Merritt. We have spoken about that.
Let me ask this. Your folks get the item on Monday. How much time do they need to do their thing? Do you know that?
I do not know yet because we have not been in a position to actually look at things. Discovery is ongoing concerning different items that we have requested from their criminalists, things that we believe we should have been afforded automatically under Rule 15.1b, and it's an ongoing process.
So what are you asking for today?
Judge, we don't want to wait 3 weeks. We want these immediately. The state's criminalist performed his examination on September 18th. He completed it the morning that Mr. Merritt was arrested. Arguably, it was the catalyst to his arrest. Now, the state is getting a second expert, and as I've indicated in my pleadings, we defer to the civil rules when there is a ambiguity in the criminal rules. It's one expert per topic. They have their expert in the DPS criminalist, and they're trying to get a second bite of the apple before we get our first bite, and they won't even give us the apple to take the bite.
court doesn't relate to the civil rules because it's different. The state's got a burden of proof much greater than in a civil setting. They have the evidence, they have the burden of proof. If they want to take it to a second expert, they may. The fact that we have a definite deadline, I will keep Mr. Haig to that deadline. I will order that the materials related to the ballistics be provided to the defense expert by the same chain of custody procedure that the police used to get it to Mr. Haig. And I don't know what 3 weeks is from today.
March 2nd.
March 2nd. Anything else on this issue, Mr. Lamb?
Again, just to clarify, those materials and evidence will be available on March 2nd for our consulting expert to pick up from the Department of Public Safety.
And if Ms. LaSecre, after talking to Mr. Haig, says that's not doable, I want you back here next week so we can argue that issue.
Judge, may we have until the 4th just because of scheduling issues, and that's a Friday?
March 4th.
Thank you, Your Honor.
And then, Mr. Lamb, since you do have the floor, I read your pleadings with respect to deposing Governor Ducey. Anything to add to your pleadings?
Judge, I'm sorry, if I may interrupt. The state was not aware that the court would be hearing that motion today. I believe when we
You don't want me to deny it today. I can hear it another day.
The only thing I wanted to let the court know was that it was my understanding that Governor was represented by counsel and they were going to be filing a pleading. So I just wanted the court to know that.
Well, I don't have to hear it today if you don't want me to hear it today.
If the court would like to make an order today, that's fine.
I read your pleadings. I'm trying to garner how the governor meets the criteria 15.3A2, that he's material to the case necessary to propose a defense or investigate the offense.
Judge, obviously, we didn't expect to go forward, but I'm very happy to address the court's concerns. According to the Form 4, Mr. Merritt was arrested at 6:47 p.m. Likely before he even left the parking lot of the Walmart in Glendale, the governor was tweeting, "We got him." Clearly, there was communication between the Department of Public Safety and the governor. He had intimate knowledge of the investigation. We see
This for that is,
well, frankly, there was an Associated Press article where his spokesperson indicated that the government had been in constant communication with the Department of Public Safety and specifically Director Milstead on the day of the arrest. We seek to explore in a very limited fashion what knowledge and information the governor was privy to at that point, insofar as it may constitute impeachment of other witnesses pertaining to their knowledge of the investigation only. We are willing to submit to a protective order. We are going to keep this reasonable. We are going to keep this brief. We're willing to seal the transcript. Mr. Merritt has executed a written waiver of his presence, notwithstanding his right to be present. We're trying to do this in the most efficient way while protecting his rights and to effectively represent him. This does go to the preparation of the offense, or I should say preparation of the defense at trial. This is part of our investigation. What is it that was being circulated between 6:47 and 6:52? What were the facts and circumstances leading up? Because there will be other interviews that we want to do in conjunction with this within the realm of law enforcement. And this is a predicate or threshold issue that we respectfully believe we need to get into, and there are no reasonable alternatives.
recognizing there may be a hair's breadth difference between investigating and fishing. I'll let you work from the bottom up rather than the top down. So your motion to depose Governor Ducey is denied at this time.
And is that without prejudice to re-urge if we get different information in other interviews?
Unfortunately, yes. I have to rule on what I know at the time. We have a hearing set for the 19th. Anything else for today, Ms. LaSecre?
No, thank you, Your Honor.
Mr. Lamb?
We will see you at that time.
All right.